Okay, so if everybody's comfortable, and we are joined here this morning by Andrew Moon in our marketing team. If Andrew could just confirm that it looks like everybody is online, I'll make a start.
People have joined. Yep, we're good to go.
Thanks, Andrew. So good morning to everybody. As I've said, thank you for joining us. I'm here this morning with my partners, Kate Benifer and Caroline Duran-Millett, to talk everybody through the changes on the law relating to sexual harassment. So throughout the session this morning, there is a Q&A function available in this Zoom webinar. So if you do have any questions for us, please do feel free to post those questions in the Q&A box. If I could ask everybody to avoid the chat function where possible, just because we will struggle to keep up with things on the chat function because of the number of people that are on the call. I can assure you that we will circulate the slides used this morning after the event today. And we're going to start off with a poll. So it's a confidential poll. We can't see who's answering the questions here. But if Andrew would kindly just launch the poll for us, what we'd firstly like to do is just get a bit of a feel for what our attendees this morning have done already in relation to the sexual harassment reforms. There we go. The poll is on your screen. So whilst I give everybody a little bit of an opportunity to complete it, I thought it's probably worth me just saying, I'm sure it hasn't escaped anyone's attention that it is a very busy time for employment lawyers and HR professionals alike at the moment. So as well as the sexual harassment reforms, we've got our new Labour government. And of course, we are expecting more reforms. So Financial Times reported yesterday about the sort of day one employment protections, the unfair dismissal protections, and that we're expecting, and some sort of caveats perhaps around the probationary period. So it is going to be a busy time. Once the poll is finished, Andrew is going to pop our LinkedIn profiles in the chat box. So please connect with us on LinkedIn. We'll invite you to our group on LinkedIn if you're not already in it, and you can keep up to speed over the next few months with those proposed changes. So if Andrew's happy just to close the poll and share the results with everybody. Okay, so the overwhelming majority of people on the call have not yet had the opportunity to do anything to prepare for the changes that are coming in October. So let's not worry. Of course, you've done something, which is get on this webinar today. So that's always a step in the right direction. But it's good to see that there's a few businesses out there that are carrying out their audits, they're reviewing their policies, they're getting some training organized. So I think what we can see there is all steps in the right direction. I've popped some household names up on the presentation just to be able to share with you, the fact that we see this all the time. It's in the media. We know why it's important. The reason we're here today is basically because despite provisions of the Equality Act, being enforced for a number of years, there's persistent reports in the media and generally seeing claims about the sort of surge in sexual harassment issues over recent years. So basically, sexual harassment in particular seems to be a problem. Sorry, I see someone's raised a hand. Are they able to just pop something in the chat box to get a message over if there's a technical issue? I'll continue in the meantime. Andrew, please do let me know if there's any technical issues. So the reason we're here is because the stats that we've taken from the Trade Union Congress report last year are that 3 in 5 women have experienced sexual harassment, bullying, or verbal abuse at work. So really high figures. 2 in every 5 are saying at least 3 incidents. So it is a really serious issue, and that's why we've got this new legislation. Before I hand over to Caroline, I'll just do a quick overview of what we're going to cover in the session this morning. So we're going to kick off with looking generally at what is harassment, so a bit of a refresher for everybody. I'm sure you all know this stuff, but it's always really helpful just to go over it again. Vicarious liability, so the concept of the business, the employer being responsible for the acts of those employees. Sexual harassment specifically, so looking at perhaps some workplace behaviour, some examples. We're then going to move on to the all reasonable steps defence to harassment. We'll focus then on the new positive duty that we have to prevent harassment, and then finally the practical steps that you need to do to comply with the new duty. So basically looking at what your business needs to be doing to make sure you are up to speed and where you need to be. So I will hand over to Caroline, who's going to start with what is harassment.
Thank you, Lauren. So today we're going to be looking at harassment, not just in relation to sexual harassment. We are going to be dealing with that specifically, but it is unwanted conduct, which is uninvited conduct that the individual, the recipient, does not want. And it also relates to a protected characteristic. There are specific characteristics only which are relevant for harassment, which we will deal with. So it's not just vanilla bullying, which is somebody being unpleasant or unwanted conduct in relation to a person that is not related to a protected characteristic such as sex or race. But we're looking at unwanted conduct, which also relates to protected characteristic, which either has the deliberate purpose or inadvertent or accidental effect of violating somebody's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. Now, with that, there are two limbs. There's a subjective element. Was I actually offended, intimidated? Did it violate my dignity, that comment? If it doesn't tick that box, if I wasn't actually upset or offended by it, then we don't get to the next stage, which is there's a sanity check. Is this objectively a reasonable response? And there have been cases when people have been particularly sensitive or particularly had a thin skin when the employment tribunal said it's not reasonable for that person to have been offended. So what we're going to be talking today is both when people are deliberately trying to offend somebody and also when it's inadvertent. Now, I have to say the vast majority of cases I deal with, either as acting for senior execs or acting for employers who are having to advise on tricky situations or we're having to do workplace investigations, it is inadvertent. The person hasn't meant to upset somebody. And quite often it is an attempt at a joke or a banter or sense of humour which has gone wrong and has upset somebody else and it was inadvertent. So next slide, please. Thank you, Lauren. So the characteristics which are covered are age, sexual orientation, disability, religion and belief, sex, gender reassignment and race. The two which aren't covered are marriage and civil partnership and also pregnancy. Now, however, they will still be covered under the other branches. So there was a recent case in which I think it's Nicola Hines. She was called overly emotional and hormonal when she was pregnant, and she still received a 350k payout as compensation for the discrimination which she suffered. So I just want to reassure people that there's not carte blanche for people to be discriminated against somebody because of pregnancy or because of maternity, for example. They're still covered under other areas of discrimination law. So in relation to age, there was an interesting case that you might have seen recently where a gentleman received a £3 million payout in relation to age harassment and discrimination. He was called an old fossil who couldn't manage millennials. And his manager, the CEO, said that he wouldn't hire anybody over 45. He received £3 million overall, not just in relation to harassment, and this has happened after he was replaced by a younger worker. Also in relation to age, there was an interesting case that offering a gentleman a chair, the oldest person in the room, he considered that to be age discrimination. Now, the Employment Tribunal said on the facts, he was offered the chair because he had a recent operation. It wasn't related to his age, but potentially a gesture like that could be seen as age discrimination. There is also a case which was age and sex discrimination, when a female was called a dinosaur and also menopausal, and that was age and sex harassment. And also, there have been cases in which it said that comments such as back in your day could potentially be age-related harassment because it's connected to their age. So comments about somebody's what generation they're in, whether they are a millennial or a boomer, comments like that, anything in relation to age. Some areas that we see is that people have sensitivity is in relation to celebrations of birthdays and parties and comments like that. So we need to be careful in the workplace in terms of practical application. Disability. There was a case in which a lady who was suffering from cancer, she was working from home, and some of her colleagues were asking her how her cozy day at home was. And those kind of comments were disability related harassment. Also, there's two tricky cases which show some of the challenges that we have dealing with people who are on long-term sickness absence. One related with the HMRC. A manager sent birthday cards to all of his team. He sent a card to somebody who was on long-term sick. She had said previously she didn't like getting cards, and the act of sending her a birthday card when she was on long-term sick was a disability discrimination act of harassment. Also, there was an act of harassment when somebody posted a picture of their top managers and made a lovely comment about it online, but they had not included somebody who was on long-term sick. And that post itself was an act of discrimination and harassment because they weren't mentioning them as one of their top managers when they were sick. So there's real challenges that we have. Also, we need to be careful in relation to a growing area that we're seeing, which is neurodiversity. There's a growing awareness and growing more people are being diagnosed and identify as being neurodiverse, which can sometimes be a disability. And I predict that that's an area which we're going to see more cases in relation to comments being made about somebody who is neurodiverse, and somebody is upset about that. So I think that's an area with which there needs to be training about in particular. There was a case recently, which was a very high profile with Lloyd's Bank, and a gentleman during race-related awareness training had used the N word in full during training, and he was dismissed for gross misconduct. It actually transpired that he was severely dyslexic and disabled, and the Employment Tribunal said that he should have received a warning and training rather than being dismissed. And his comments were an act of his comments were connected to his neurodiversity, his disability, and he received over 400k in terms of his compensation. So again, in terms of training, we need to think carefully about how we disseminate the information and make sure that in his training, he was told it was a safe space to speak out about anything that he had concerns about. So we need to make sure that when we do the training, we're careful about it. Sexual orientation. There was a case recently where a gentleman got £35,000, which was partially in relation to sexual orientation discrimination, where his manager said he should start a straight pride event because he was tired of homosexuals rubbing his face in it, and there was lots of other homophobic comments that were made, and that was sexual orientation harassment. Now, interestingly, the EHRC guidance gave an example that quite often we see the issue of the so-called people saying it was just banter. And the guidance said that there was banter of a homophobic nature between two colleagues, which it didn't qualify as harassment until a very offensive homophobic slur was used, which actually did offend the other person. And they said that at that stage, the mark was, the person had overstepped the mark. And at that juncture, the person actually was subjectively upset and offended by the comment, and it no longer was comments which he was comfortable with, which again shows the challenge that we have in the workplace, knowing where the boundary is when we are trying to give training and make sure that we have appropriate policies. Gender reassignment. This would count if somebody was dead named, for example, or comments were made about a person or a family member who was undergoing gender reassignment. There was a case with the Essex Police Force. A long service officer had undergone gender reassignment. They were using the radio, and on occasion, I think it was 3 occasions, they were incorrectly identified as being male. They raised claims of harassment, saying this really was offensive. They looked at the Employment Tribunal looked at the facts of that, and they said, well, actually, the radio operatives did not know that you had undergone gender reassignment, and also you have accepted, as a matter of fact, you have a deep voice. As a factual finding, the Employment Tribunal said, well, a cisgender female with a deep voice may be misgendered as well on the radio. It wasn't an act of harassment. It wasn't connected to or related to the gender reassignment. In relation to race, there was a recent case again where a manager commented on a person's braids being like the Avatar braids, and made offensive comments about them being, I think, alien-like and Avatar-like. And also there was a comment about when they were listening to music, a comment about, are you listening to ghetto music? And that was successful as racial harassment. Also, there was a case where a manager mispronounced an individual's name 4 times in one day, and that constituted race harassment as well. So I think that gives us an idea of some of the scenarios which aren't related to sex. In terms of sex, there have been a number of cases in the press where a female is being told to wear makeup. That's sex harassment. The comment to call somebody frumpy, that was described as being intrinsically related to somebody's sex. Ditto, calling a man bald was intrinsically related to their sex, and that was an act of harassment against a man. And one of the situations that we have had in relation to sex training is to make sure that when one is giving the training, that people are aware that this can be a catalyst for people to talk, but we have to make sure that people are very careful as to what their words are and how they describe the training. There was a case many years ago that after training, people had described it as woke and PC gone wild, and then an individual had gone on to make a series of inappropriate jokes relating to somebody's sex, and that, fresh from the sex harassment training, was an incident of sex harassment because it really offended the females who heard the jokes. Finally, religion and belief. Religion is sort of more straightforward. And philosophical belief can be more of a challenging situation to deal with. There have been a number of cases, for example, ethical veganism would count on the particular facts, potentially as a protected characteristic. Somebody's belief in climate change is potentially. Poppy wearing, the Employment Tribunal said, well, while that is admirable, that's not a protected characteristic, and ethical vegetarianism did not count as a protected belief. There was a recent case in which a female received £55,000. She was a social worker, and there was an LGBTQ plus meeting at work, and there was one of the gentlemen had dressed his dog as in a dress and said his dog was gender fluid. The individual and another female said that they made some direct comments about this. They were then banned from the group and disciplined, and they raised claims and said what you actually were upset about, it related to or was connected to our gender critical views. And as such, as gender critical views are protected, they received payouts. So there are sometimes competing interests that we in the HR world have to navigate our way through. Next slide, please. So who is protected? There's a really wide umbrella of protection for people in the workplace. Workers, partners, agency workers, also job applicants. And again, it's really important that your training covers the people who are meeting and greeting and interviewing your job applicants, because there have been cases and situations we've had to deal with when comments have been made to somebody which have been they have found offensive, and there's been a claim of harassment in relation to job applicants. So again, we need to be careful in relation to that. Next slide, please, Lauren. The specific status of sexual harassment. So sexual harassment is still the type of harassment that I have to give advice on and deal with the aftermath the most of. In terms of, so it's the colloquial, it can be sort of sexualized harassment. It's not just in relation to somebody's gender, but there's a sexual element to it. So, for example, there was a recent case, we're looking at sexually explicit emails or messages. A manager was sending peach emojis to a worker, which apparently reference somebody's bottom. So there was numerous peach emojis and kiss emojis. He invited her to dinner. Overall, her settlement, she got 420k in relation to her settlement because of his sexualized harassment and other discrimination against her. So I haven't, well, the vast majority of cases I see with sexual harassment, alcohol is involved and or WhatsApps, usually both. In relation to staring or leering, there was a case recently where a manager, part of the harassment case against him was that he winked at his member of staff. So this related to a waitress. She had just started. She'd been there for a very short period of time. He winked at her. There was creepy behavior. In the interview, he said that she had pretty eyes. She said that she was desperate for the job, so she took it. He was offering her lifts. So overall, she got a settlement of about £41,000, and part of the claim related to his winking and the way he looked at her. There have been cases that the way that somebody has looked at somebody up and down, that is sufficient. A very short period of time of looking somebody or assessing them or praising them, that can be sexual harassment. Yes, in terms of sexual comments or jokes, there's the case, I think it was late last year, where a chef got a payment of £80,000 in relation to her manager singing the Victoria Woods risque or bawdy song, and I think the Employment Tribunal said that there were also disconcerting gestures with it, and she received a significant compensation in relation to the sexualized harassment as well as the discrimination. Unwelcome touching or hugging. There was a case where a female manager was accused of harassing a man. She was touching his shoulders and making him feel uncomfortable. And that's something, as a general point, sexual harassment, men can be harassed by females. We tend to think of it in the more traditional way, but usually the main thing is that there's usually a power dynamic. Quite often it is the manager, and the people don't feel that they're able to speak up. So there was inappropriate massaging on the facts that failed, but obviously we would recommend avoiding any kind of touching, hugging, kissing at work. To give an idea of some of the tricky situations that we've had to deal with in the past, there was a case in which a gentleman and a lady, after a Christmas party, they were engaged in consensual kissing at the end of the evening. He then touched her lower back, and she said, well, that was unwanted conduct. I consented to the kiss, not to be touched in my lower back area. And that became a question as to where the consent was and what was unwanted conduct and not. So there are very challenging areas here, but there's some very simple, basic things that we can be doing to protect our staff from any kind of harassment and sexualized harassment, and also protect colleagues from being accused of sexual harassment as well. Next slide. And finally, vicarious liability. Now, why are employers interested in what employees do or do not do? Well, employers are vicariously liable for what their employees do in the course of their duties, in the normal course of events. Now, as the slide says here, we can't control everything, but I think it's important that in the normal course of events, not just includes what we're doing in the work day, it also includes Christmas parties as an obvious one, but also informal birthday parties. If somebody is suggesting going for drinks after work with a few colleagues, work trips, seminars, conferences, they can be a danger area, particularly travel abroad or away from working at home if there's hotel trips and overnight trips. However, if the business can show that it's taken all reasonable steps to prevent harassment, then it won't have culpability and liability. Now, I know that's something which Kate will be talking about later on. One of the things that I do want to touch upon is that I think individuals, it can crystallize their thoughts when they appreciate that they can be named in the harassment claims as well, not just in relation to the entity, but an individual. I could be named personally in an employment tribunal claim. So again, there's ways to help focus people's attention to ensure that there's a dignified working environment, which my colleagues will be talking about more next.
Okay, thanks, Caroline. So Caroline's gone through a number of case examples of what it can cost, and it can be expensive. So just a reminder of what that cost is based on. So for an unfair dismissal claim, for example, there is a cap in place. So you know that if you sack somebody unfairly, there is a maximum liability for that. But for discrimination, and harassment is part of discrimination law, compensation is unlimited. So it can be as much as the tribunal think is just and equitable. But that is based on some calculations. So one of those things that the tribunal will look at is loss of earnings. So how long is somebody going to be out of work as a result of the discrimination? And the other element is the injury to feelings that somebody suffers. So how upset was that person, and how serious was the conduct to cause that level of upset? Those limits came from a case called Vento, and every year those bands are reviewed and usually are increased. So from April 2024, so currently the bans are on the slide. I won't read them all out, but it's worth bearing in mind in terms of the lower bands that if there is any act of harassment or discrimination at all, the minimum cost it's going to be would be £1,200. So, not an insignificant sum of money. If there's a minor act of harassment, you're at least liable for £1,200. It goes up substantially, and the top band goes up to nearly £60,000 for injury to feelings. And that's in addition to other elements of claims, such as loss of earnings, personal injury claims, that sort of thing. And the way that claimants end up with the huge sums of money that we see in the press and some of the sums of money that Caroline mentioned is where people's career is lost as a result of the treatment, or they're never going to work again. So the cases where people are getting millions of pounds or hundreds of thousands of pounds, it usually means that they've got middle or upper band of vento, so the injury to feelings has been significant, but also that they've probably suffered an injury as a result of it, so mental health has been damaged or something like that, and that they are unable to work going forward. So that's where the high sums come from. When you're dealing with a discrimination case, individuals will potentially, if they've got lawyers involved, will start to try to tell you how bad their injury is, how bad their feelings have been hurt. If it's a one-off incident, you're likely to be in the lower band. But if it's more than one-off, if it goes on over a period of time, even if perhaps you say it's just banter or it's minor comments, if it's a series of minor comments over a period of time, you're likely to be into at least the middle band, and that's obviously then into substantial levels of compensation. Next slide, please. So Caroline mentioned briefly in terms of liability, this defence that's available to employers. So the starting point for an individual is they can sue both the person, the perpetrator, the person that carried out the discrimination, and their employer. And the argument is that an employer is generally liable for what employees do in the course of their employment. So certainly at work, but potentially at work-related events or via social media that might be connected to work, things like that. If there's a sufficient connection to the workplace, the employer is likely to be liable. However, there is a defence that you can run as an employer. So even if the claim is successful, so even if discrimination is proven, you are not liable as an employer. You basically argue that you did everything that you could do to stop this from happening in the first place. So you took what's called all reasonable steps to prevent the harassment. And now this applies to harassment for all of the protected characteristics that Caroline mentioned. Obviously, for the purpose of today, the key that we're looking at is sexual harassment, but it does apply to all of them. Now, it's all reasonable steps, not just some reasonable steps. And there have been a number of cases where employers have tried to argue that they did something to stop it. It's not their fault that the employee went off and did something silly. They tried to prevent it, but it is all reasonable steps. So things that have failed, for example, there's a case where an employer said, well, we've provided everybody with training. We've given everybody some training, told them not to discriminate against each other, told them what discrimination is, and therefore we should be protected with this defence. But the training that they'd run was 2 years old, and the tribunal said that is not enough. The training hadn't been updated. It wasn't necessarily out of date in the sense that the law had changed, but people hadn't been refreshed and reminded that this was an ongoing obligation, and that wasn't enough for the employer. Similarly, having a policy is really useful, but in itself, it's not enough. So there's been a case to say that relying on a policy wasn't enough without some training as well. So I know a lot of organisations and clients we see will have an induction pack where perhaps they send out a equality and diversity policy, or they have a statement somewhere that says, we don't discriminate against each other, or no one's allowed to discriminate. But that in itself is not going to be enough. That policy, that written statement, that documentation needs to be brought to life and shared with the employees, and there needs to be up-to-date training. Now, a case that did succeed where the employer was able to rely on the defence was a case against the Ministry of Defence. And here they did succeed in saying that they'd taken all reasonable steps. But what they'd done is they'd used an assessment tool which had assessed what the level of risk was, what the issues were. That had then resulted in a policy which was bespoke to their organisation, and they'd followed that policy and implemented training. So the caution here is that if you want to be in a position to rely on the defence and allow the claim to just proceed against the individual, then you need to be able to do more than take your sort of standard policy or template policy, things like that. So if I can have the next slide, please, Lauren. So some of the things that you might want to do to be able to rely on this defence. Now, just a reminder, this defence is what's in place at the moment. This is a defence against discrimination claims. This is not the new duty. This is not something you have to do currently. You will have to do things shortly, and Lauren will deal with that shortly. But this is about what you can do to be able to defend the claims that may be brought against you. So one thing that is definitely going to be worth doing is having a policy. And we asked at the beginning about, who's got policies and who's reviewed them. So have a policy that is relevant to your organization. So, as employment lawyers, we're often telling people that, just a template policy that you found on the internet or you've taken from another organization, sometimes works, but often for things it isn't going to be enough. And here, when you're looking at taking all reasonable steps to prevent things within your business, it's probably not enough without some further thought. So how does it apply to your organization, and what is the level of risk that you're dealing with? But have a policy and actually implement them. Don't just stick it in a staff handbook or on the intranet and leave it for individuals to find themselves. Keep those policies under review, so make sure they're up to date. They're not just there from an induction or in a handbook, they're regularly looked at. Make staff aware. Having a policy is great, but if nobody knows it's there, that's no help. So make them aware of the obligations as well as the implications. So what happens if they breach the policy? Do they know how serious it is? Do they know what action will be taken? And does that actually happen? So you're able to demonstrate that you've told them that you'll take it seriously, but then you do take it seriously. Are people made aware that they could be personally liable? So if there is an act of harassment or discrimination in the wider sense, individuals could be liable, and are they aware of that? Has that been shared with them in the policy or through other communication? Provide training to everybody. Now, we run equality and diversity training for clients on a regular basis, and it's quite surprising how people are shocked by what we tell them, what we tell them in terms of what you can and can't say. Sometimes genuinely people really didn't mean any offense by it. They really did think something was funny. They thought it was banter. They thought they were being nice. They thought they were, for example, paying somebody a compliment. And actually they pay somebody a compliment, the other person gets offended, and then you've got a claim. So that training needs to be more than just saying you can't discriminate against somebody, there's a risk there. People need practical examples. They need to understand, well, what are you saying I can't do? What can't I say? What kind of examples are we talking about? So that you're actually bringing it to life and helping people realize how something could be interpreted. So the comment, you look nice, lots of people would think that that's a nice thing to hear. But if it's said in an inappropriate context, or to somebody where there perhaps is a history of saying it to them more than once, or where they know that they don't like attention, people need to understand that the context is everything and can make a big difference. And if somebody is offended, as Caroline mentioned, it's not about the purpose, it's about the effect. So all of that needs to be explained in the training. There probably also needs to be additional training for those in a managerial role so that they can spot issues and deal with them straight away. If staff have crossed the line, a manager needs to be able to step in because they can see the problem. If employees are coming to you and saying, I think you should do this, or this would be helpful, you need to act on those initiatives. That's not to say you have to do everything somebody suggests, but you certainly need to consider it and work out why you're not doing it if it's not an appropriate thing to do. And then if there are complaints, so if none of these steps work and something still comes through as a concern, you need to deal with it, and you need to take it seriously, and you need to deal with it promptly. Otherwise, you're exposed to the risk of saying, well, we've got your policies, but you're just not properly implementing them. So, complaints shouldn't be dismissed out of hand. If somebody wants to raise a concern informally, you might say to them, well, it's fine that you don't want to raise a grievance. It's fine you don't want to pursue things, but we still need as an organization to take this seriously, because we still need to protect other people from this happening again. So you may still need to take action against the alleged perpetrator. You may still need to provide further training or updates to the team to make sure these things don't happen again, even if somebody didn't want to raise a formal grievance. It's not going to be enough to just say they didn't want to raise a grievance, so we just dropped the point. So that's what we've got at the moment. Lauren's now going to talk about the new positive duty that's coming in to force next month.
Thanks, Kate. So I'm hoping that the constant theme that's come across so far is very much all organizations are going to have to live and breathe this stuff. We can't just give you an out of the box solution. Everything is going to be tailored. So we have in force from the 26th of October 2024. So next month, we are going to have a new statutory duty. So we have some changes. So a new piece of legislation comes in. So this is the Worker Protection Amendment to the Equality Act. Which basically adds a new section 40A to the existing Equality Act 2010 that we have in place. So I think the key thing for me to say to everybody at this point is it's not optional. There is no opt-out. So it's here to stay. And that duty that you've just heard Kate talk about, the sort of the defence rather, or the defence that we've previously had, that defence is effectively being turned into a new and positive duty. So what does that mean for you practically? So I've said basically there is a new positive duty, but it does just relate to sexual harassment. So when the new laws come in next month, there is no duty to prevent other harassment. There's no positive duty, albeit, as Kate said, you can still rely on the defence. It's not limited to just preventing sexual harassment by other employees. So what we're saying there is actually it's in the course of employment, you have to take all steps to prevent harassment. It's a broader duty. So the example here is it includes third parties, so preventing harassment by third parties. I'm going to say a little bit more later on third parties, so I will come back to it. The reason I'm highlighting it now is because obviously being able to try and take steps to prevent harassment by third parties, it's a lot more difficult than when it's just in the confines of your employees. And I know it's going to be very, very relevant to the businesses that we have on the webinar today that are perhaps in healthcare, in health and social care, retail, hospitality, all those sectors where you have very, very sort of public facing roles. So that's where we are in terms of what this new duty is going to look like, and I can probably liken it to perhaps the gender pay gap reporting, but obviously that's in force, and that does just relate to gender pay gap reporting. So at the moment we just have this one, it's going to relate to sexual harassment. It's not going to stop you taking steps to prevent all harassment, but just to make it clear, that's what the duty refers to at the moment. So how will it be enforced? So first and foremost, the Equality and Human Rights Commission will have enforcement powers. So a little bit when you think about data protection in your organisations and the fact that the Information Commissioner's Office have enforcement powers. The first point I just want to touch upon with this new duty is to say that the Equality and Human Rights Commission can carry out their own investigations. They can issue notices, so unlawful act notices and action plans on your business. And they can also issue your business with fines, the value of which is unlimited. So as well as taking into account the fact that claims, tribunal claims cost you money, Caroline and Kate have shared all the examples that are relevant with you today, there are other enforcement powers through the EHRC. In addition to that, the new duty that we have sees a 25% uplift on tribunal awards for sexual harassment if, as the employer, you have failed to take all reasonable steps to prevent harassment. We've put on the slide, remember, compensation claims for harassment is a form of discrimination. They are therefore unlimited. It's probably equally for me to point out, there's no standalone claim as such in the employment tribunal for a failure relating to this new duty. It has to be as part of a harassment claim, but you do have the separate EHRC enforcement powers. So that's where we are with this new duty. We already know that harassment and discrimination claims are really expensive for your business. So to have a further 25% uplift on there is going to make it really, really costly for you if you're not taking all those steps. The final point I've put on the slide is just to remember, if you take all reasonable steps, you can rely on the defence that Kate has talked about. You've taken all reasonable steps to prevent harassment. It's a complete and an absolute defence. So your business is effectively off the hook. And the claim can be brought against the individual personally. And that's one of the things, again, that with the training that we do, we make it clear to individuals, the claim will be against you as well as the business. So we do have a few anomalies before I jump on to third-party harassment. It's just to make it clear. I think the government always do this when they bring in new legislation, but for the sort of eagle-eyed amongst you, the statutory defence that Kate spoke about was the defence that we've had in place for a while. It's under Section 109 of the Equality Act, and it refers to taking all reasonable steps. It makes it very clear you have to take all reasonable steps. Some steps are not enough. So your training that's 2 years out of date is not enough. Your policy on its own is not enough. The new duty that's been inserted at Section 40A, for some apparent reason, misses the words out all. So it just says you have to take reasonable steps. That is not the new duty. That's just what the wording is in the legislation. So we think it's going to be relevant perhaps to uplift. So perhaps you won't see such a big uplift. But it's just to say it is there. It does seem to be a bit of a missing wording in the legislation, and we'll probably expect to see some case law on it when it comes in. So the guidance that we have from EHRC basically sets out that there is a duty. There is a duty to take all reasonable steps to prevent sexual harassment, and that duty includes the third-party element, basically. So you need to prevent any kind of harassment of your employees. As I've said, the legal provisions don't quite address it. And generally speaking, employers tend not to be liable for the acts of third parties. Now, there is a sort of get out there, which is again Section 109, that says anything that's done by an agent for a principal with the authority of that principal must be treated as if done by that principal. So you're looking at situations, perhaps sort of agency worker type situations, where someone is authorized or instructed to do one thing on behalf of the other. So in which case there can be some third party liability. But generally speaking, if we're looking at the sort of concept of what customers do or say, or what members of the public that might be at a certain establishment, the employer, generally speaking, is not responsible for that, but you do have a duty to prevent all harassment, all sexual harassment, that is, of course, against your employees. So now for the important part. So we've got this duty, we've already had a defence in place, and that's now been turned into a positive duty by EHRC. What reasonable steps can employers take to prevent harassment? So we're going to start looking at policies. So the first thing to say is your policy needs to be specific and it needs to be tailored. Remembering always that what is a reasonable thing to do for one business will vary depending on the size of that business, the sector the business is in, the environment you work in, the resources available to you. So there's no general definition of what's going to be reasonable here. So the approach of EHRC is very much at the outset, businesses need to consider the risks that have been identified. So prior to your policy update, the right course of action, of course, is to carry out a risk assessment first. So in your risk assessment, you do need to identify scenarios. So maybe perhaps identify previous incidents of harassment or scenarios you could face, so specific risks, and of course, an action plan to prevent it. In terms of your policies, it's going to be a bit of a no-brainer, isn't it? You're going to have to update your equal opportunities policy, your equality and diversity and inclusion, whatever you call these policies, harassment and bullying policies. They will need to be updated, based upon what we have in this new duty and what comes out of your risk assessment. You'll often hear the phrase zero tolerance being used, so making it clear we don't accept this type of behaviours in our organisation. And it will take us to the culture point later. I mentioned it earlier, you really need to sort of live and breathe these points. So on the policy point, having updated your ED&I policies, your harassment policies, you also probably need to consider updating your disciplinary policies or your grievance policies. And some of you, of course, might have social media policies as well, because no doubt your risk assessments will be throwing up things like, making it clear what is acceptable in terms of your social media use, what is acceptable messaging on things like WhatsApp, Slack, Microsoft Teams messaging. You'll also need to make it clear, if you're not doing so already, that harassment can constitute gross misconduct. Another thing to say is that anonymous reporting systems for harassment also have a good place in most businesses. So have a look at some of them when you're considering your next steps. Of course, it's not as simple as just updating those policies. They need to be lived, they need to be breathed. So the next step is obviously to then ensure that your policies are actively followed. So making sure employees are aware of them, keeping them constantly under review, documenting the changes that you make, and then finally ensuring that they are followed. Give it some really careful thought. Sometimes less is more, so keep the policies as straightforward as you can. Things like often a relationships at work policy can be a step too far, because it sort of adds in another level of complexity. People feel they're doing things wrong, etc. So look at those policies, get them reviewed based on the risks you've already identified. Training is next. So there's no doubt with the new rules coming in October, so 26th of October, there is no doubt that staff, all staff that is, now need to be provided with sexual harassment training. Kate touched upon it earlier. You also need to ensure that extra training is given to managers that are dealing with issues of harassment, so spot the issues, identify them, be able to deal with complaints. The training that's offered needs to be specific to the reality of your business. So as an example, if you're a business that has a hierarchical structure, so you have lots of senior people at the top, you might have to focus on issues that can arise as a result of a power imbalance. If your organization has lots of people working remotely, perhaps their usage of messaging systems is greater. So it's identifying the hotspots, considering, I guess, what characteristics are in your industry, and looking, is there a risk of third-party harassment? Particularly, I mentioned hospitality, retail, health and social care, all those sectors, and dealing with that when you do your training. So the training for your employees, you need to go through some of the points Caroline covered at the start, but making it feel real for them. What is harassment? What's your business doing? What are you doing to deal with harassment? What do you do if it happens? Setting out examples of workplace behaviours, understanding banter, that dreaded word banter. It can create so many problems in so many organisations. You can't ban it. It helps people get by the day. People enjoy the work social aspect, but understanding banter, what's acceptable, what to do if people see harassment, what to do if they suffer it, and then finally, what to do if it's reported to you. Management training obviously needs to cover all of that, but also needs to make it clear that we're setting the tone from the top of our organisation. What can managers do to encourage people to report harassment if they've suffered it? Spotting the signs, understanding the importance of apologising when things go wrong, and understanding the signs that people might be suffering harassment at work. People that are perhaps, they haven't said anything yet, but perhaps you can see they're taking more time off, or there's a reduced engagement or productivity. So that's kind of where you've got to with the sort of training aspect. As I've said, it needs to be tailored, it needs to be specific, which takes us nicely to culture. So again, with your risk assessments, you need to be looking at what your culture is looking like now. So sort of taking a look in the mirror. You know, what can you do, I guess, to improve your culture? There's lots of ideas out there. Staff surveys can be helpful, focus groups, but also doing a past review on harassment. Have you dealt with harassment in your organisations? What have you done? What are the learnings? I would say that as part of your audit or part of your risk assessment process, doing a survey is going to represent another reasonable step. So satisfying that defence in terms of taking all reasonable steps to prevent harassment. If you've done a survey and you've acted perhaps upon the suggestions of your employees, that is going to be another tick in the box towards satisfying your duty to take all reasonable steps. Identifying, of course, as we've said, that some businesses, their structures are perhaps going to be more susceptible than others, and just sort of recognizing, you know, perhaps if you've got a number of employees that work in a nightclub, they're going to have a completely different set of risks to remote IT consultants, as an example. Or if your business is focused on sort of a remote working model, you've got lots of people using messaging systems, perhaps posting images in WhatsApp that they think are funny, that is going to be a different risk to a business that actually recognizes where people socializing is an issue because alcohol's involved. So all those sort of very different types of risk need to be dealt with when you do your risk assessment. So look at your structure, look at how employees socialize, identify the risk associated with your business. Where you can, try and assess the effectiveness of your culture to date, what you need to do, and then ensure that you've got your policies in place, that you do make it clear that you're going to discipline or dismiss where appropriate when there is harassment. Keep records of what you're doing, the decisions that you've made, so you can ensure some kind of consistency, and then keep auditing yourself. So what we're going to be saying to you now is it is imperative that you do an audit, that you do a risk assessment, but keep on top of it. And the final point before I move on to sort of just looking at CCTV as an example is just to say encourage reporting. There are also some anonymous reporting tools out there, such as Safe Call and Speak Up, which again can be a helpful step to demonstrate that you're taking all reasonable steps to prevent harassment, as well as being able to effectively deal with any harassment that takes place. The next point I wanted to just discuss briefly is to say, is CCTV useful in preventing harassment? I'm conscious of time, so what I'd like to say is it can be, but before you go ahead with CCTV as a tool to prevent harassment, do seriously consider the need for it and consult your employees first. So the benefit of it, I guess, is fairly obvious. If somebody's wearing a body cam, it's perhaps going to prevent certain types of behaviour, particularly from third parties. But one point you do need to take into account is that recordings will undoubtedly be personal data. So from a data protection perspective, you need to ensure that your policies deal with it. How will it impact receiving data subject access requests? There's a whole host of issues that can come up. You need to ensure that the use of any CCTV is proportionate. But generally, just have in mind that employees often have a view that use of CCTV can send a message that now they're not trusted as employees. So perhaps giving people the option of a body cam would be more appropriate than enforcing a complete usage of CCTV if that's something that your organisation is considering. I thought I'd finish on the case of Go and Asda stores just as a timely reminder that it's not just about women complaining of harassment. So Mr. Go, in the case of Asda, was awarded £29,000 injury to feelings because he was kneed in the bottom by a female colleague. And the tribunal determined that perhaps because it related to the bottom, that was a part of the body that where it was a sort of a sexual issue, as opposed to sort of, I don't know, a slap across the top of the head. So it's both genders you need to be aware of. Another key factor with the case of Go and Asda was the fact that Asda stores failed to properly deal with the complaint when it was raised, and the tribunal did not think that they would have treated a female employee complaining of the same treatment in the same way. So to wrap up for this morning, the takeaways for you are that we have a new duty. It's a positive duty to prevent sexual harassment from the 26th of October. Ahead of this date, you do need to understand what your organisation needs to do to prevent sexual harassment, and get those audits and risk assessments completed. We can assist them with you. Our details are on the screen now, and we'll send around further information later today with the slides and with a copy of the recording. It's not going to be one size fits all. It's going to be about completing those audits and those risk assessments, and working out, what has happened, what is your risk, what is your specific risk, what measures have you got in place, what further actions do you need to take. What sort of language do your employees use? It's very, very specific. So identifying those risks, and then putting policies in place, putting training in place, and ensuring that you've got that very, very vital culture piece nailed, will all help you in terms of being able to demonstrate that you are, as an organisation, taking steps to prevent sexual harassment in your workplace. I'm going to ask Kate if there's any questions that were in the question and answer box that she wants to just share with the group, or whether there's none to discuss.
Yeah, there's been quite a few. So there's a couple of questions about whether we have a template audit or risk assessment, and I've started responding to people, but we haven't got a template for the reasons that we sort of talked about, but information will be coming out about the audit service that we can offer and assist with clients for carrying out audits. And there were a couple of questions around the steps for dealing with potential inappropriate behaviour within certain organisations. So one with a care home, what steps, I suppose this is for Lauren really, what steps should be taken to deal with potential inappropriate behaviour from residents? So how do we protect our staff? And similarly, one with teachers, how do we protect them? So I don't know, Lauren, is there anything specific for those types of organisations for the reasonable steps?
Yeah, I think so. I mean, if we take the care home example first of all, I guess the danger is obviously not just limited to employees or workers, a sort of wider definition that we deal with. It's, as Kate mentioned, it's residents, it's perhaps also visitors as well. So it's quite broad. So in terms of, I think if we look, specifically, our policies obviously are circulated with the employees, but you can have notices within your care homes about what is acceptable. You often see it, don't you? I'm often horrified that I think people would be abusive to reception staff and stuff, but you see it, we know it happens. So having notices up that sort of state what your culture is, that states what's not acceptable, repeating those things on your internet sites, if you have them. So basically drawing them to the attention of the third parties, emanating that message with the residents, because you can still bring it to the attention of residents about what is acceptable, what is not acceptable. I guess when you move into the schools remit, schools have probably got an even sort of tougher test to satisfy, because they need to be able to demonstrate that their culture is such that everyone associated with that school, the pupils, the parents, the third parties, the suppliers that come in, that this is the culture that we have, and that we just do not, we cannot accept any sexual harassment, and these are the steps that we're taking. So it's a huge communication piece, I think, is the answer.
Just one question I think we've probably got time for. It's just come in, which is quite interesting about timing. So somebody's asked whether there'll be any grace period, and my view is the answer is likely to be no. There's been notice that this legislation is coming in, so employers are going to be expected to have dealt with it in time. But a question's just come in to say, well, if we've done our risk assessment, we've got our policy in place, we've done all that in time, but we haven't quite trained everybody, is that okay as long as we've started? And I think it's going to depend on, if you were really unlucky to get a claim of sexual harassment before you finished all the training, then I think my view would be, unfortunately, it's probably not enough, because you won't have taken the steps that were necessary to prevent it. It's a preventative measure. And if the training is lined up and it's due to happen soon and it hasn't yet happened, and there is, if you could say, therefore, there is an act of harassment, there is a potential risk area. But bear in mind, this isn't a standalone claim in its own right. This is a claim for, this is an obligation, but only relevant if you get a claim and that leads to a potential uplift in compensation. So I think if you've done all the steps that are described and you started the training, you're in the, definitely going in the right direction. And you'd be pretty unlucky to get a claim that fell in the middle of your training sessions before you'd finished them. And hopefully you wouldn't get a full uplift if you've shaken most steps that you need to take, even if not completed.
And I think also the sort of the EHRC enforcement measures, we can't give you any guarantees, but I'd like to think they won't be out there completing their first investigations on the 26th of October, but who knows? But yeah, I think the key is act in a timely manner. As Kate said, you'd probably be quite unlucky to get a claim when you had all your training booked but hadn't quite got it done yet. But I would be mindful of December and employment lawyers' favourite time of the year, the Christmas party season, where we tend to see the biggest amount of sexual harassment complaints. So if that's everything, we'll stop there. We are more than happy, all three of us, to take any questions that people have, and by email or through the LinkedIn group. Thank you for those that have already sent over requests to connect on LinkedIn. We'll invite you to join our specific HR and employment law group later today, and certainly watch this space over the next few months. I think we're going to be quite busy with the new reforms that are coming in to employment law. I hope everybody's found the session informative today, and thank you all for joining. Thanks.
Thank you. Thanks all for joining. Thanks, Lauren. Thanks, Kate.